No, it's gone. It's gone.
Okay. Aaron, you're so fired. And I'm going to tell everyone in Hollywood, don't let him direct a movie. And I know lots of people in Hollywood, Aaron. All right? Okay, so copyright. Again, I promise this is going to be fun. We will make this fun. It's actually a pretty interesting discussion. I am going to be showing you guys a presentation that actually comes from the government copyright office. They actually, of course, have an interest in making sure that people understand copyright. And in addition to this video being available, there's actually, the PowerPoint being available. There's a video of the gal who originally put this presentation together actually giving a talk about this. So the way you're looking right now is making me nervous, Aaron. Don't touch it. Don't touch it.
I don't want to touch it, but I don't know if it would get your audio. It says it's on, but I don't know.
This is not going well. This is not going well at all.
We're good. We're good.
Okay.
I didn't have that other hand fire. But now you're in.
You ruined it. This was going to be, I was going to win an Academy Award for this video, Aaron, and now it's all over. I'm not even going to be a nominee now. For worst documentary. All right, so you can actually watch the gal who put this presentation together give this speech, and she probably would do a far better job if she were here, but you get me instead. So let's go ahead and let's talk. I just want to start by talking about some popular myths of copyright, because people absolutely are incredibly poorly educated on copyright, and I see this a lot with folks who have kind of grown up with the internet. They have some misconceptions in mind when it comes to what's available on the internet. The first up here says if it's on the internet or Google, it's in the public domain. And this is absolutely not true. Just because it's on a website does not mean it is yours to do with as you choose. Those photographs are owned by someone. And when I say they're owned by someone, the copyright is owned. We'll talk about what that means and how you get copyright. If there's no copyright notice on the image, I don't need permission. Wrong again. A photograph does not have to have any notice of copyright on it in order for the owner, the creator, to retain copyright. If you don't profit from the use, you don't need permission. No, that has nothing to do with profit. If you remove the image after notice, you don't owe any money to the copyright. Yeah, again, wrong again. If they're nice, maybe you won't owe them anything. But if you break copyright law, you're subject to you can be subject to a copyright lawsuit. If I alter the image X%, I don't need permission. No, it doesn't matter how much you alter an image. If it's not your image, it's not your image. And then if I only use part of the image, I don't need permission. This is really the same thing as what we said before. Again, if it's not your image, it's not your image. Okay? So it says this in the syllabus for a reason. I actually, and I figured that just the fact that we have a lecture on this would stop people from doing this. But I've actually had students turn in work that was not their own before, and it is absolutely not okay. Obviously, we are going to promote best practices here. When do you acquire copyright protection? And the important thing, we have a couple of important things here. The important thing I want you to stress to you here is that rights begin at the moment of fixation. And we'll reinforce this as we go through this presentation. The minute that you take a photograph, you own the copyright for that photograph. You don't have to write anyone. You don't have to fill out any forms. You don't have to put a copyright symbol on your photograph. You don't have to do anything. That photograph is your photograph. Okay? You own the copyright for that image. And then it says copyright protects original works of authorship that are fixed in a tangible form of expression. And expression is in bold. And that's because this is one of our key terms for this lecture. I'm not going to ask you guys to memorize every little bit of this. I'm not going to say, in what year did the copyright law change from, this to that? That's not how this works. But I will expect you guys to understand what can be copyrighted and what cannot be copyrighted. And what can be copyrighted is tied to this word expression. And we're going to illustrate what we mean by an expression as we go through this lecture. So the two important things here: you can copyright an expression, and then the rights, your copyright rights begin at the moment that you take the image, that you create the image, that you write the play, that you write the script, that you whatever. Okay, this applies to a number of things. We're looking at this in the sense of photography, but there are obviously a lot of other things that have copyright protection. What is not protected? And we have a whole list of things here, and then one word in bold: ideas. So when we talk about what can be copyrighted, what cannot be copyrighted, expressions can be copyrighted, ideas cannot be copyrighted. And like right now, that doesn't make any sense at all to you. That's okay. We're going to work our way to that point. But let's go through some of the other things. What's not protected: concepts, discoveries, titles, names, short phrases. Although short phrases and slogans can be covered under trademark, not copyright. But different part of law. Let's see, improvised speech and dance. Works consisting entirely of information that is commonly available and contains no originality, which you'd think that would be common sense. And then anything written or created by the U.S. government, because the U.S. government doesn't really own anything, we own it. We pay for it, so it's for everybody. What rights do the owner control? What does the owner control? To make copies, to distribute copies, to perform, to display, to make derivative works. This term derivative works is relatively important, and this kind of speaks to on that first slide. If I only use part of the image, or if I change the image X amount, if an image is cut up, manipulated, that is what we consider a derivative work. And derivative works are solely the right of the originator of the work. And now we may get into discussions. Some of you who are art, I don't know if we have any art majors or people taking art classes or whatnot, but there's kind of a whole vein of the art world that is based on something called appropriation, and we can debate the legality of it here. That's always fun. This part, there's a couple of slides here that, again, you don't have to write this down. This is the part where I'm talking about. I don't expect you to remember all of this. There's some key components I want you to remember. Copyright law is tricky and complicated, and so there are a few simple key ideas I want you guys to remember. And I'm sharing some of this information with you to show you how ridiculously complicated it can be, and why I want you to remember, these simple ideas rather than try to memorize all of this. And what this is going to speak to here is this idea that how do you know if something is copyrighted? And the two-word response that I always want from you, if I ask you how you know if something is copyrighted, is you always assume. Always assume. Okay? If it's not your work, you don't own the copyright. If you don't know whose work it is, you don't own the copyright. Okay? And these slides up here, we're talking about, how long does copyright protection last? For the life of the author plus 70 years. 95 years for a corporation. How many of you can look at something and make a determination, well, I think this was originated by a corporation, and it was about 97 years ago, so I think we're good as far as copyright goes. Anybody? Nobody? I can't either. That's why I say always assume. It's ridiculous to think that you're going to be able to look at an image or a work and make some determination on how old it is, what Copyright Act it's under. Because of course we have, in really small print up there, asterisk, current act, and in the bottom down, since 1978. So then now we're like, okay, well, which copyright law does it actually fall under? Is it United States copyright law? Is it international? I don't know. Where did the image originate? So there's all kinds of things that you need to be aware of. Public domain. We have this thing called public domain images. A public domain is an image that is out of copyright. It is not a copyrighted image. What is in the public domain? This is tricky again. This is kind of speaks to this we assume thing is works out of copyright. I love that line. What does that mean? Well, it's in public domain. It's work out of copyright. How do you know? You don't. In the United States, again, what's the originating? Where did the image or the work originate? All published works before 1923, or works that fell out of copyright for failure to register or renew under 1909 Act, or for lack of notice before 1989. So it just gets more and more complicated. So I'll ask you now for the first time: how do you know if an image is copyrighted? You always assume. Okay. And now next time when I say that, in unison, louder, more mouths moving. All right? All right. Is copyright notice needed? This speaks to, I said that copyright begins at the moment of fixation. You don't have to fill anything out. Since 1989, you don't actually have to give notice of copyright. You don't have to fill out any paperwork. You can put notice on. It's a good idea to put notice on some of your works. And of course, the proper notice is the copyright year, the little copyright symbol, year, and name. But this does not necessarily mean that an image is not copyrighted if the image does not have this. And you don't have to notify anyone. Who owns copyright? This one's actually kind of, I find this really interesting. And this is important for you guys to know because depending on, if you are working for someone, depending on the conditions that you're working with, the copyright situation changes. So who owns copyright? If you are a freelance artist who is kind of just contracted, or if you're working on your own and then someone buys your work, you own the copyright yourself. You may give someone a limited right to that copyright, but you own the copyright. However, if you are an employee, if you are hired, you're a full-time employee, the company that you work for owns the copyright. Okay? And this is important to remember, and you know, this is photographers who work for companies, they'll often make very clear delineations between my time, company time, my equipment, company equipment, because they want to own their images. They don't want the company to own their images. So when you are employed by a company, you are shooting for the company, you are using the company's equipment, you do not own the copyright of that work that you create during that time under those conditions. The company owns that copyright. Fair use, limitations on the owner's rights. We have this is another one of these key terms. Fair use means that there are situations under which we can break copyright law, or not necessarily. We're not breaking copyright law. We can ignore copyright law. We can use images that we do not own the copyright for in these situations. And we're going to spend some time talking about what these situations are and maybe going through a couple examples as well. Fair use, some of the situations are educational research purposes. Technically speaking, anything that we do in this classroom is protected. So if we, although I've asked you guys not to use copyrighted images, there is actually one assignment where I'll ask you to go ahead and search for an image on the internet. It's only once. Wait for it. It's not a project of your choosing. It's a specific project. And it's okay for us to do that because this is an educational setting. It can be, we can use fair use for research purposes. We can use it for criticism, news reporting, teaching, scholarship. And you're going to notice that most of these really fall in two categories. Either A, it's educational in nature, it's for school, or B, it is for newspaper. So it's newsworthy, it's for criticism, these would fall under news. For educational research, let's see, teaching, scholarship, these are all key terms that would, indicate educational situation. Class handouts, but it has to be very short excerpts. I can't, I can't give people entire magazines, books, whatnot. And there's actually a couple of different parts of law that I'd be breaking if I did that. So I can give you a short excerpt from a book, but I can't give you an entire book. And then for newspapers, quoting purposes, but you can't necessarily just reprint something entirely. So quoting purposes, criticism, commenting, and this would refer to art, writing, speech, scholarship. What's not fair use? And I'm going to have to explain this one a little bit more. Let's see. Using a photograph or other image to illustrate a newsworthy story. And then it says in parentheses, because the subject of the story is newsworthy does not make the image newsworthy. And the example that I like to use is a few years ago, Hillary Clinton came to campus and spoke here. And obviously, newspapers wrote stories saying Hillary Clinton's coming and speaking in Cheyenne. And they would want to use an image. Hillary Clinton is newsworthy. If you go out on the internet and search for images of Hillary Clinton and just grab any image of Hillary Clinton and use that, you're still breaking copyright law. Hillary Clinton is newsworthy. That particular photograph of Hillary Clinton is not. So just because an event, that you have a story that's newsworthy doesn't necessarily mean that you can just say, well, I have a newsworthy story, I can just grab any image I want because it's newsworthy. The image itself has to be newsworthy. Now, if the situation were a little bit different, if, let's say, we'll go back to my libel case where I got a picture of Sean and put in a puppy and made it look like he was punting a puppy. The local newspaper covers this story, and they find the photo and they reproduce the photo. That is newsworthy. I no longer I can't say, hey, I own the copyright on that. You can't use that image because the image itself is important. The image itself is newsworthy because I'm being sued over the image. So they can pick that image up, and the other newspaper that wants to run a story on that libel case can pick that image up because that image itself is newsworthy. And then what is not fair use? Creating a similar photograph that incorporates elements of the first photograph. And this is where we're going to spend most of our time. There's a couple of different ways that you can infringe on copyright. The first way you can infringe on copyright is just taking an image that does not belong to you. Sean took a picture. Or I'll quit picking on Sean. Val took a picture, and I decided I liked that picture, and I just took that picture and decided I was going to use that picture. That's a copyright infringement because I just stole her image. And that's pretty clean. Everyone can understand that that's copyright infringement, that that's wrong. But then there's another way that we can look at copyright infringement that's a little bit trickier that we're going to get into, and that is I see an image that Chris has created, and I like the image, and I want to use the image, But instead of saying, hey, Chris, I like your image, and I'd like to use that image, can we work something out? I just decide, you know what, I can make that image. I don't need Chris. I'm just going to recreate that image that Chris made and call it my own. That is also copyright infringement. And we'll look at what we're looking at specifically in order for that to be looked at legally. Parody is another area of fair use. If you are making fun of the original work, then you are covered by fair use. Now, there's a key here. I said, if you are making fun of the original work, it's fair use. This was a famous photograph taken by Annie Leibovitz, a rather famous photographer, and they lampooned her for the movie poster for a movie called Naked Gun 33 1/3, which is old, and most of you are too young to know who that actor is or have seen the movie. But they were specifically, this was considered fair use because they specifically were making fun of this photograph. They didn't just steal the photograph and use it just because they thought it was a good photograph. They were specifically making commentary on this photograph. I want to give you guys an example and let you guys try to talk it out and discuss it and see how you feel about it. So we have two images here. The original image is on the right. The secondary image, and I want to say this was for it was a late show, and I think it was Conan O'Brien's show, where the image was manipulated. And let's kind of deconstruct this. Okay. The question here that we're looking at is this copyright infringement? Is this fair use because it's parody? Okay? So it is the same image. Okay? The question is, do you think that it is copyright infringement, or do you think that it's fair use under parody? And I gave you a key a little earlier that should help you. It should help you with this. Yes?
I think it's copyright infringement.
Okay, why?
Because they manipulated the photo.
Okay. But it's parody. It's funny.
There's no direct link between the two photos.
Okay, yes. There's no direct link. Okay, what are they making fun of?
Breast implants.
Yes, but what's the parody of, really?
Breastfeeding.
It's a combination of breast implants and the Got Milk campaign. That's what they're making fun of. Okay? Where do you think that image originated? Is that an image that originated as part of a breast implant campaign?
No.
Was it part of a Got Milk campaign?
No.
Okay, so what the parody is of is important to whether or not it would be covered by fair use for parody. So they actually did lose this argument as to whether or not this was fair use. Yes, it was a joke. Yes, it was it was parody that they had in mind, but it was not a Got Milk photograph. They could have used any photograph of any baby for this. It didn't have to be this specific photograph. They could have taken their own photograph and done the same thing, and they would have been fine. So there's no link between the original photograph and the parody. So that's why this is not considered fair use. Change of medium is still an infringement, and this kind of speaks to this idea of appropriation. And I like to give this example because the appropriation here, the change of medium, was what's the word I'm looking? I don't want to say perpetrated because that sounds like it's really bad. It is bad, but the person who actually broke copyright here is an artist by the name of Jeff Koons, who some of you may have actually heard of. He's a notable contemporary artist. His work sells for quite a bit of money, and he deals heavily in appropriation. So the original image, of course, was on the left. He doesn't actually create all of his own artwork. He has like it's kind of like Andy Warhol in the factory. He just decides, oh, I want to do this work. And he takes it and sends the idea off to all these people that work for him somewhere. And they create the work and he slaps his name on it. Which, don't be jealous. It just makes him a lot smarter than the rest of us. So, and he was sued successfully by the original photographer because, of course, it was a change of medium, but it was the exact same image. It was the exact same concept. And so he did lose that case. And he's been involved with a number of those. Another notable artist that's been involved, and I think this lawsuit is still going on. I'm sure everyone's familiar with the Obama Hope image. That was created by a street artist by the name of Shepard Fairey, who's quite notable. How many of you guys have seen the Obey? The Andre the Giant face? That's the same guy. He does this whole, I don't know if you would call it a campaign or what, but it's called Obey. And he created not only that campaign with the images of Andre the Giant all over the place, but he created that Obama image. Well, the original image was actually a photograph that was shot by a photographer for the Associated Press. So when he created that image and it became popular, the Associated Press actually sued him for copyright infringement. And I think this is still going on. I don't think it's done yet. And a very famous artist does very well, so you got to be really careful. It doesn't matter who you are. And again, this kind of speaks to, like I said, there's this whole vein of art that falls under this idea of appropriation. And you still have to be careful because just because it's art, and if you say it's appropriation, it's this style of art, doesn't mean it's not copyright infringement. Why do we worry about copyright? And again, this is one of these things where I don't expect you to know all these numbers. What I want you to understand is that there are monetary damages. This can be serious. This is not like, oh, my bad, sorry, I'll take it down. Everything okay? We're cool, right? Because it doesn't work that way. There's a couple of different types of damages that can be awarded, and it depends on some of the conditions as to how much money can be awarded. So we have something that's called substantial monetary damages. And what this is, it says actual damages or profits. What that means is if I steal an image from Matt and I make $20,000 because I stole that image, Matt's entitled to that $20,000. Or if I take an image from Tia, and I got that right? Yeah. Oh God, thank you. I'm so bad with names. This is terrible. You were absent for a week, so I'm gonna blame you for that. That's not my fault. I hope we're still picking up here. All right. Anyway, so I steal an image from Tia. Aaron's just smirking. He's not actually giving me any feedback at all.
I'll tell you if it's not working.
Okay, all right. So you'll stop me if it stops working. All right. So, okay, so I steal an image from Tia, and because I steal the image, she then has a difficulty selling the image, and she loses out on a $15,000 contract. She can then sue me for that $15,000. Statutory damages. It says $750 to $30,000 and up to $150,000 if the image infringement was willful. Now, statutory damages can only be awarded if you have actually registered your copyright. So you don't have to register your copyright. However, if you do register your copyright and someone steals your work, you actually can get more money out of them. Attorney's fees, and then in some cases it can be a criminal offense. Don't ask me. I'm not a lawyer. I don't know exactly what that means. It's just it's bad. I know that. It's not good. Who's responsible? And this is kind of scary as well. In fact, this is unbelievable to me. Who's responsible? The company that directly infringed, the employees or individual who participated in the infringement or should have supervised, or anyone who publishes the infringing image whether they had knowledge or not. This is scary stuff. Okay? That means Aaron has a company. It's time for me to pick on Aaron. Aaron has a company, and Jennifer works for that company, and she infringes on copyright. Aaron doesn't know that Jennifer infringed on copyright, but he's the person who should have been supervising her, so he now is in trouble because she broke copyright. Investors in the other owners in the company, even though they're not directly supervising, they can actually be party to it. And then let's say Rebecca publishes the image that was provided by Aaron's company. She's now attached to this copyright case as well. So this is scary stuff. I mean, this is all kinds of people who had no idea that Jennifer was such a bad girl. She gave me a little frowny face. I feel sad now. I'm all like melted. Oh, I'm sorry, Jennifer. You're not a bad girl. Are now implicated in this copyright case. So this is scary stuff. Actual copying. So we talked about there are really two ways that we can look at copyright. We have the first way, and that is that you just simply stole someone's image. The second way is that you recreated an image. And that's where this term actual copying comes in. In order for a case to be successful for this type of copyright infringement, you have to show that the alleged infringer had access to the original and the alleged infringer actually copied protected elements when created the second image. And this is where we're going to get into this idea of expression. These protected elements are what are going to make up this concept of expression. And then this first part here must show the alleged infringer had access to the original. This is an important concept as well, because a lot of folks, when I teach this class, they say, well, I'm just going to go take like thousands and thousands of pictures at Grand Teton. And any one time anyone tries to print any photographs of Grand Teton, I'm going to sue the hell out of them. Well, it doesn't quite work that way. Okay, you have to show that. So let's say Matt has an image, and you got to help me here. It's an M name. It's Meryl. Why can't I remember that? Yeah, I know. And we have the director, the movie critic, and the actress all together right here. Okay, so Matt creates an image. Meryl creates an image that Matt thinks is too similar to his image, but Matt never published the image. So there's no way Meryl could have actually seen the image. Okay, that is not copyright infringement. That's just, that kind of happens. And in some cases, this is tricky. We're going to talk about this, and I actually have some students who actually get mad when we start looking at some of these. Where, you take an image, and you've seen that image so many times, or an image similar to that so many times. Yes, it's entirely possible to capture an image that is close to an image that someone else captured. There's certain things that when you take a photograph of it, it looks that way, and we're going to look at situations like that and a portion of law that covers that. And then we're also going to more closely examine what constitutes actual copying, so you guys really understand what we're looking at. Some examples of derivative work here. Here's an example. Sunday Newsday, the designer borrowed, I love that they put that in quotes, borrowed images from several sources. Here are the original images. So you have the skyline, and you have these two people running across the desert with clocks for heads, and they just cut the images apart, use them as they saw fit. And again, derivative works. That's not fair use. It is still copyright infringement. If you don't own it, if If you did not create the image, you do not have the copyright. So this is considered copyright infringement. Substantial similarity. This has to do with actual copying. Substantial similarity is it's a term that they use to determine whether or not it's the criteria for whether or not a case can actually go in front of a jury. In a copyright case, what happens is Amanda has an image. Meryl creates an image that Amanda thinks is too close to her image. She sues. She can show that Meryl had access to the image. What happens here is it doesn't automatically go to a trial. What happens is the two sets of lawyers, the two parties, come together with a judge, and the judge looks at the images. The judge then compares them and decides whether or not he believes there's enough substantial similarity that it can be heard in front of a jury. Now, the funny thing that you're going to see as we go through these cases is this is really where it all happens with these types of cases. Because once a judge decides there's enough substantial similarity, there's not enough substantial similarity, usually that's the end of it. If the judge says there's enough substantial similarity that I think this can be heard by a jury, usually the infringing party settles out of court at that point. Because at that point, they feel, typically this means, I'm going to lose this case. So I can either go the distance and figure out what the penalties are going to be and fight this legal battle and rack up lawyers' fees, or I can concede that if the judge thinks there's substantial similarity, chances are the jury's going to say that there's substantial similarity. I might want to cut my losses now and see what I can get out of this with. And just make an offer and say, okay, is X amount, or how much do you want? What do we have to do to make this go away? Now, like it says here, there's no hard and fast rule for substantial similarity. They're just simply compared. And there's some things that they're going to look for. We're going to go through a list of that. The elements that are compared, and some of these are going to sound similar and some of them are similar. The posing, how people are positioned, how objects are positioned. Lighting, where is the light coming from? What are the light sources? Where are the light sources positioned? The angle, and this would be angle, perspective, viewpoint. Seems pretty similar to me. Angle, perspective, viewpoint. Is it a low angle shot? Is it a high angle shot? Is it close up? Is it far away? What's going on with those? The background. What's going on in the background of the image? Is there something in the background of the image in one image that's also in the background of the next image? Shading and color. Is it monochrome? Is it monochrome meaning one color? Is it achromatic, meaning no color? Is it full color? Is it vibrant? What are the color properties to these images? And then it says total feel and concept elements. So what are the things they're going to look for is that they're looking for elements in the particular photo that tend to make it original and unique. And as we go through some of these examples, it's amazing the stuff that people do. Some of them are just blatant, outright, and you can see it in a second. Sometimes you think, well, maybe not. There's some leeway here. What was the deciding factor? And then as we look at them, you'll see what some of these deciding factors were. But they're looking for specific elements in the images that would make those images unique. And then again, back to this whole, I hinted at this earlier, and I want to reinforce this now. The idea-expression dichotomy. An idea is not protected. The expression of the idea is protected. And I know that still doesn't make a lot of sense, but we're going to go through and we're going to see what that means. That there are particular expressions of an idea. That's what's protected. Okay. And then we have this area, it says, the way the idea is expressed tends to merge with the idea itself. It says there's no protection. And that's that one that I was talking about where certain things that just kind of look that way when you take a photograph. And we'll see some examples of that as well. So idea versus expression. So here's an example. I want to the first image, the original image is the one on the left, and then there's two images shot by another company on the right. And what I'll do here now is on these case studies is I'm going to ask you, do you think this is the idea and it's not a copyright infringement, or do you think that this is an expression of an idea and it is copyright infringement? So what do you think? Do you think that the second and third works are an infringement of the first work, the copyright? Amanda's giving me a nod. Val's giving me a shaking of the head. Amanda, why do you think that it's so you think that it is copyright infringement? You think, but what about it specifically? That's all right. I won't pick at you too much on this one, but next time I'm going to make you. Okay, well, we're really going to discuss this. Val.
I think it's not copyright infringement because I think they only took the idea of using the babies.
Okay, using the babies how? Because you're right. I'm not trying to pick on you, but there's a key to it here.
And I'm trying to get it to.
Okay. I'll help you out on this one, especially since it's one of the first ones, and you were brave enough to actually, commit. The judge said this was idea. This was not substantially similar enough, and basically the judge said, this is what it looks like when you put babies on a white background. This is just babies on a white background. You can't take a photograph of babies on a white background and then just decide until the end of time that no other photographer can take photographs of a baby on a white background. Okay? And then the things that we would look at that tend to make it unique. Okay, so we have a couple of different images here. The first one, we have actual babies. There's several babies. Has this circular shape. This one here, we don't have the circular shape. It's the same baby. Okay? This one here, we actually have toys. So there's some differences here, some subtle differences between the images that might make it a little easier to differentiate, one image from another. So again, babies on a white background, that's an idea, not the expression of an idea, not a specific expression of an idea. Now, would it have been different if, let's say, the image on the upper right, the babies were all arranged in a circular pattern? Would that have been different? It very well may have been. Okay, now we're looking at, this is an element of this particular expression of this idea that has been copied. That's where we get into, that you would get into trouble with copyright infringement. I think the original is on the left, secondary on the right. Idea or expression? I got one expression, I think, from Matt. You guys are... The microphone can't pick you up, I swear. I am the only one that anyone's going to hear. Oh, Aaron's... Go ahead, fine. Try to make a liar out of me. I'm going to make Aaron come stand up here just because he's messing with me. Okay, so Matt says expression. Anyone else agree with Matt or disagree with Matt? You agree with Matt. Okay, why? What? Okay, and this is where part where I hope that this can become fun for you guys. What are the specific elements that make it an expression?
Same shirt, same shorts, same sandals, same bag.
Exactly. Okay, now the company that was being sued for infringement tried to say, this is just what business casual looks like. But does it have to be a red polo shirt? Does it have to be tan khaki shorts? Does it have to be sandals? Does there have to be a bald guy? Do there have to be columns? This is my game I like to play. It's did it have to have? Did there have to be? It's my HAFTA game. And it's HAFTA. HAFTA. That's how we determine copyright court cases in this class. The HAFTA test. So yeah, I mean, there's all kinds of things going on in this image. It's like, why does it have to be shot from behind? Okay, all kinds of elements in this image that make it an expression. So yes, it's a pretty obvious copyright to me. Yes, ma'am.
I think the only things that are different between the two photos that would make you think an expression is the ground. One of them's walking on tile, the other one's walking on concrete, and the fact that from one photo to the other, the badge has switched sides.
Yeah.
That's
So
the
what you're
only
saying is
differences in this photo.
there are so few differences that it's just really obvious. I mean, there's just there's actually fewer things that you can point to that aren't directly copied. And yeah, I'd say that definitely makes this a pretty blatant case. This one gets people heated up. Okay, so the original image on the left was an image that was captured by a photographer for the book Midnight in the Garden of Good and Evil. And when Warner Brothers decided that they were going to film a version of this, the photographer said, hey, I got all kinds of shots you might like. And Warner Brothers said, well, we're going to go our own direction. Have you seen this movie, by the way? It's fantastic. You got to watch it. It's really good. Now, that's not what we're talking about in class today, but it's a good movie. I have 2 movie buffs here, so I had to get that out. Okay, so what do you think? Idea or expression? Okay, one expression. Everyone else is on the fence. Chris is trying to formulate an idea. An opinion, excuse me, not an idea. He has lots of ideas. No one wants to disagree or agree. See, this is where it gets fun. This is where it gets tricky. Why do you think it's an expression?
I'm just leaning more towards expression. It seems like they did it from a different angle, but it's not like if you were to look at these 2 photos and be like, oh, I wonder where they got the image for that. It's like you would look at the book and be okay. They clearly took the image from this.
Well, but this is actually prominent. Right. This is the statue has a name. They call it Bird Girl. And yeah, so I mean, some people would say, well, this is just a prominent statue in that area. And that's what it looks like when you take that picture of the statue. So what specifically? You got to be more specific than that.
Well, I mean,
what are the elements? Think about it. What was that list we went through? It was, angle, viewpoint, color, positioning.
I mean, like, I think the position is where they could probably get away with it. But I mean, like, if you were to take the photo from the same angle, it's like there's the trees with like the leaves hanging down, there's light shining on the statue. It just looks different from different angles.
Okay, anyone want to jump in here?
It seems like Warner Brothers wanted to save a couple bucks and not give permission.
Okay, you think Warner Brothers wanted to?
So
Yeah.
They're just trying.
They tried to change it up enough that it wasn't going to get them in trouble.
Right.
They did get in trouble still, and they looked at things. And Matt kind of pointed to some of these. The elements that specifically they were looking at is that it's pretty much shot from the same angle. One shot's tighter, closer, but the reality is they're both they're dead on. I mean, you're looking right at it. You're shot. Both of them are shot from about the same height. You know, they didn't move up or down or to the side. Monochrome and achromatic. Neither image is in color. The original image is a black and white. The secondary image is a monochrome. That played a part in the judge's decision as well. And then the way they have the moss hanging from the trees as well. That was considered in this case as well. So the judge did decide that it could be heard by a jury, and then of course Warner Brothers paid the photographer. Scenes affair. We've talked about how some images just kind of look like that. That's what this scenes affair is. So things that tend to look a certain way in any 2 photographs of the same or similar subject. So, a photo of a building will look similar to a photo of the same building. So I can't take a photograph of the capital of Cheyenne And then anytime someone says, you know, I'm going to go take a picture of the capital of Cheyenne and publish it in the magazine, I can't sue them and say, but I own the copyright for all usage of photographs of the capital of Cheyenne. And if you're looking straight down the street from the depot, okay, anytime someone takes that photograph, it's going to look kind of the same. Okay, that's what this is talking about. So there's I can't claim copyright on that. Here's a case where the second party, the party that was being sued, argued, this is what it looks like. Okay? What do you guys think? No what?
That it's not what it looks like. That the top one shows all the shadow.
And it has like a fisheye lens.
Okay, so we have some distortion. You guys, you're not making a case for it being copyright infringement, though.
Are we supposed to make a case for that?
Oh, well, you're supposed to make whatever case you think. She said, I thought that I heard her say that she thought it was copyright infringement, but then she made a case for it not being copyright infringement.
Oh, I said no, I didn't think it was.
Oh, you don't think it's copyright infringement? Okay, good. And then you're saying it's not copyright infringement. Okay. Why not, though? You got pictures of shoes looking over the edge.
One's a bowling alley. It's not even related to.
They're not. Neither of them are bowling alleys. You're too far back. You're too cool to sit up front, Chris, and it's obvious that your vision requires that you sit up front. There's no bowling alley. I get that all the time with this image. What is that? It's a street with cars. Okay, so no bowling alley.
I mean, so the first one has like more of a wide angle. The one on the bottom is like more of a tight.
Okay, so there's some differences there.
Different pants, different shoes. That one on the bottom has.
Okay, there we go. Different pants, different shoes. What else?
There's a suitcase. In the
Suitcase. Okay, good. Now you're looking at the elements that would make this a unique image. Okay? So the shoes are different, the pants are different. There's no case. You know, we got the pigeon. You know, and then the judge looked at the remaining aspects of it and said, this is what it looks like when you're a businessman looking over the edge thinking of ending it all. That's what it looks like.
We're going bowling.
Except for when or when you're going bowling. I don't know where. I don't know. I don't know where you go bowling, but I think this is dangerous. You may want to rethink your bowling alley.
It's like a pair of shoes laying down in a bowling lane.
Oh, okay. Now he's laying down. Okay, I get it now. And now the windows on the other building are like lights or something across the top. Okay, now I get it. What are you talking about? They're completely different. One is a guy standing in the edge of the building. The other guy's the guy taking a nap in a bowling alley.
I didn't realize those were shoes. I thought they were ball returns.
Yeah, they weren't even. It's a bowling alley. Why are you comparing these two photographs? This is crazy. I'm going to talk to somebody. That O'Brien's lost it. These photographs are nothing alike. This is absolutely crazy. Again, kind of reiterating some of these things we've been looking at. So what's copyrightable? What's protected? The expression. Again, expression's in bold for a reason. The total look and feel. What's not protected? The ideas, or where the expression is merged with an idea, and then commonplace subjects and compositions. So again, oh, sorry, here, now it's time for me to play games now. Okay, so what's copyrightable and what's not copyrightable?
Always assume.
Well, good answer, but wrong question. Okay, what's copyrightable?
Expression.
The expression. What's not copyrightable?
Idea.
The idea. How do you know if something is copyrighted?
Always assume.
We always assume, yes. Okay, because if you don't know, you assume that it's copyrighted. That's just the way it is. And then this is just a bunch of case studies, and I want you guys to just look at them and tell me, and we'll try to go through these relatively quickly. Infringement or inspiration. That's where you got to be careful, because I'm inspired by this. We got to be careful not to copy it entirely. So original image on the left, the cover to a Fat Boy Slim CD on the right. Okay, we'll get away from the inspiration. Okay, I want idea versus expression. So infringement or not infringement. So I got one person saying expression, it's infringement. Infringement, you think it's idea? Okay, so now let's break it down and discuss it now that we got people on both sides of the fence. Okay, why would it be expression? Those people who think it's expression. It was Amanda. Tia's very non-committal. She's like, I'm not saying anything. Rebecca really doesn't say anything. Okay, yeah. So there's really not. That's how little difference there is. Why would you think it's an idea?
Well, I mean, that sounds like starburst now.
Okay.
Reflection's different on the wall.
And that's what starburst looks with the reflection? Is that what you're saying?
I mean,
okay. It looks like a different time of day. Okay. Well, but what about the positioning? Does it have to be positioned right where it is?
I mean, it's called.
Does it have to be, the hands down like this? Fat Boy Slim doesn't have anything to do with it. Don't change the subject. Okay, so you got the hands down to the side, the light coming through in the middle. So I mean, did it have to be like that? So I mean, you have this backlit. Granted, backlit just looks like backlit. Starburst looks like, or sunflare looks like sunflare. But does it have to be from that position? Does the lighting have to be just like that? Does it have to be that angle? And that's where, sorry, and of course this is the gray area. I don't make the rules, I just play by them. The judge said there was a substantial similarity, and of course then they, I don't know if they settled in court. I think they did in this case. I think they pretty much all of these cases did.
That's just creepy.
That's just creepy. Well, creepy or not, that's not really what we're looking for here today. Play the have to game. Okay, so we have a couple people saying idea.
I mean, how is this an idea, but the other one wasn't?
And now Chris is just completely befuddled.
I know, this is an idea.
That's an idea? I got lots of ideas. Okay, let me ask you some questions now about the idea. Okay, so the idea is what? Horse's eye. Okay, does it have to be a black background? Does it have to be cropped in the corner like that? Got to play the have to game. Okay, these are the elements that would make it unique. Okay, and so sorry, again, it has nothing to do with my opinion. It was a judge somewhere, not me. The judge ruled that could be seen by or heard by a jury. Expression. Yeah, and it's pretty blatant, actually. And it's so. I used to like to tease my students. Every once in a while, a student will still try to argue this with me that they think it's actually idea, but it's obvious. I mean, the way the clothing drapes, the bench, the bird, all that. And then I used to like to try and mess with my students. I'd say, so do you think that the second company had to pay the first company? And they say, oh yeah. And I say, no, you're wrong, because they declared bankruptcy shortly after they lost the case. It's a dirty trick, I know. This is my favorite. I love this one. My very favorite case study. Original on the left, subsequent on the right. Idea or expression?
Is there a dog in that second one?
It's a flamingo.
Yeah, is there a dog somewhere else?
I
I think it's teddy bear.
that might be a dog right there, but I'm not sure. Okay, and the judge agreed with you, Matt. In fact, that was the backbreaker right there. Okay, so we have the idea of the projection of something on the side of the house. That by itself is fine. Is it okay, you guys are still discussing this. Really?
No.
Okay, no. So the idea of a projection on the side of the house, but where they got into trouble were other elements like the cowboy hats, the way the chairs are arranged, things of that nature. And then the backbreaker was the flamingos, which I always imagine what it would have been like in that meeting the next day, or when the lawsuit was brought, and the art director realized that their photographer did this, and the art director said, "Really? You had to have the damn flamingos? Seriously? You couldn't have done this without the flamingos and the cowboy hat. Really?" Yes. Okay, so yeah, and that's what I love that one just because of the flamingos. And Matt's a pro now. He's just like going at it. I love it. But that's what it looks like. That's Scenes of Fair, right?
He's hanging from the same angle, same like
Okay.
facial expression.
Now you're getting it. Okay.
Arm,
And hopefully everyone else is getting this as well as Matt is. It's the elements. Okay, it's not the idea that we're hanging off of the edge of the building. It's that we're hanging from the same hand. That the tie is the same. That he's wearing glasses. That it's in the intersection. That there's a damn pigeon. Okay, everything is copied in this. Okay, it's the elements. I don't know what this means. Chris is like, I'm just going to shake my head. I'm participating in class.
That's what it looks like.
I got an expression.
That's what it looks like if you take a picture out of your car window.
but
Oh, Chris is saying this is Scenes of Fair. Okay.
But at that angle, the two people.
Oh, Aaron's got you there. Okay, Aaron. Okay, Val says expression. Chris says Scenes of Fair. But then Aaron starts to make the good points. This is what it's all about. It's all about the elements. Does it have to be from that angle? Does there have to be two kids? Does it have to be the same car? Does it have to be a station wagon of that, vintage? Does it have to be luggage on top? The only thing they really changed here was, we'll make ours sepia tone. It's blatant. There's really not much to discuss there. This one makes me laugh. Yeah, this is so ridiculous, in fact, that it just kills me. Brown background, brown sweater, hiking boots with shorts. What's that? Yeah, absolutely. It's almost the exact same. Except it looks like it might have been a boy in the first image, and I'm thinking a little girl in the second image. You can't really tell. Expression. Any other takers? I got one expression. Do I hit two? Rebecca! Oh my God! She speaks! Good job! All right, so 2 for expression. And I don't even know if I need to take anything after that. If Rebecca spoke, it must be true. And yes, but and I'll have people try and argue this, but of course look at the positioning of her body. Look at the angle of the line. Look at where the horizon line is. All of these things. It doesn't matter that one's sort of updated. It's the exact same image. Okay. So you think that they went to court? This is I'm just messing with you guys again. Okay, this is the last one, and I like this example because this is an example of a company that did it right. A&E, they didn't infringe. They saw the original image on the right. They wanted to use the image, but they wanted to do something on their own thing with the image. So they did the right thing. They called the photographer up and said, "Hey, we saw your image. We really like it. We want to do something that's kind of similar to that. Can we work something out?" And the photographer said, "Sure, I like money." And that's what you're supposed to do. And then, of course, if you're... Oh, there's some more information here. Sorry. That's the last case study, but there's some more information. And then this last thing is here is just why register. And if you want to file a claim in the United States, you have to register before you can file a claim. And then if you register, there's actually more that you can get legally. Like I said, statutory, you can't seek statutory unless you actually had filed before the infringement took place. All right? And you don't have to memorize that. Just when I ask you, what happens? It's bad. You go to court. You have to pay money. Not good. And then some additional links for you guys there as well. Okay, it is break time again, and I'm not going to record again after this, Aaron, so you don't have to monitor anymore.